続きまして、スコット・ボアリック米国特許商標庁特許審判部首席審判長です。
All right, well, thank you. So the relationship between the PTAB and the courts is one that is, well, we'll see. It's developing because the addition of the post-grant proceedings, introduced sort of a new, a new interaction between the PTAB and its reviewing court. So we already talked a little bit about who the PTAB is. We are an administrative body within the United States Patent and Trademark Office. We only deal with patent matters. We have a corresponding board. You can see in red the Trademark Trial and Appeal Board that handles trials and appeals in trademark areas at USPTO. Essentially, as I mentioned in my prior presentation, there are two kinds of proceedings we do. One is ex parte appeals, where we review the work of patent examiners, and the other is AIA trials, or inter partes review and post-grant review, that are challenges to issued patents from third parties. So those are the two basic types of work that we do at PTAB. The AIA trial proceedings came into being in 2012, September of 2012, after Congress passed the America Invents Act, or AIA. And these proceedings, as you can see, were meant to be streamlined. They're more efficient and cost-effective than determining validity in the federal district courts in the United States. So I won't go through this detail, but this is in your materials. The differences between an IPR and PGR, essentially IPRs you can challenge for a longer duration, and it's like any time during the life of the patent except its first 9 months, but the basis of the challenge is narrow. Post-grant review is almost the opposite. You can only challenge for 9 months, but you have a lot more challenges that could be given. There are three parties. There's a petitioner who files the petition challenging an issued patent or certain claims of the patent. The patent owner, of course, has the opportunity to defend those claims. And the panel, our panels sit in 3-member panels for both appeals and trials. So every one of our final decisions has 3 judges. That's by statute. The proceeding I mentioned earlier, it has 2 phases. There's a petition phase where the goal is to decide whether to institute a trial or not. And if one is instituted, then we have a trial phase shown here in the green to the right of the dividing line. And there we have to finish within 12 months. There's an asterisk because there are certain limited exceptions, but most of the time we finish within 12 months. We can extend for good cause by up to 6 months. That's fairly rare. So how do we fit into the IP landscape? Well, you could see our reviewing court is the United States Court of Appeals for the Federal Circuit, which is the purple circle shown there in the middle. And the Federal Circuit hears patent appeals not only from PTAB, but also from district courts in patent cases, also from the International Trade Commission and the U.S. Court of Federal Claims, which is where parties can go to sue the government. If you're going to sue the U.S. government, you have to go to the Court of Federal Claims. So those different tribunals in patent matters come up to the Federal Circuit, and from there it's possible that the cases could reach the Supreme Court. U.S. Supreme Court does not have to take any cases. There's a petition called a cert petition, and the Supreme Court every year decides which cases it will hear and which it will not. So again, at PTAB, 2 different kinds of decisions: ex parte appeals, AIA proceedings. I didn't mention derivations. They're a very small number of derivations which have to do with whether an invention was derived from another inventor. These are fairly rare, and they are not subject to the same statutory timelines that the IPR and PGRs are. So that's the last I'll speak of derivations here. For board decisions in ex parte appeals, there's actually two paths. You can, well, first of all, you can request rehearing. You can see that little circle to the right of the square of ex parte appeals, where if you think the panel has overlooked or misapprehended something in the decision, you can ask the board panel to reconsider its decision, and they, you know, if you are persuasive, they can and will change their mind. Then the applicant has two paths. They can either go to the U.S. District Court of the Eastern District of Virginia, or what we call EDVA. There is a proceeding that you can take, and you can actually supplement evidence in that proceeding in the district court, and from there can be a further appeal to the Federal Circuit, or what happens most of the time is there's a direct appeal to the Federal Circuit on the record before the PTAB. So that's ex parte appeals. For trials, IPRs, PGRs, there is no district court option. You only can appeal to the Federal Circuit, but before you do that, you can either ask for panel rehearing, just like in ex parte appeals, or you can use the director review process that I talked about in the prior presentation, and you can ask the director to review either the institution decision or the final written decision in the IPR or PGR. You saw the statistics last time. The director does take some of these up, but it has to be presented in the right way, and but the director can take that decision. But once the director finishes and writes a director review decision, or the panel does its rehearing decision, those are both then appealable to the Federal Circuit. And as I mentioned before, the Federal Circuit hears patent appeals and other appeals from different agencies. For example, it hears veterans' appeals from the Court of Appeals for Veterans Claims. It hears appeals from the Court of International Trade, where Judge Chogroves is from. It hears District Court, Court of Federal Claims, other agencies, including the Merit System Protection Board, which are federal personnel cases, all come to the Federal Circuit. So it's a nationwide jurisdiction in these different areas, and from there, along with other courts of appeal and state Supreme Courts, the U.S. Supreme Court can elect to take a case. But again, the U.S. Supreme Court decides they don't have to hear any of our cases or the Federal Circuit's cases, and the last year or two, they really haven't been very active in the patent law area. They were active before that. I'll just skip this to say that in the U.S. District Court, to prove a claim invalid, it has to be done by the standard we call clear and convincing evidence, which is more than 50-50. It's not as high as the criminal standard of clear and convincing evidence, but it's a fairly high standard to prove that claims are invalid in U.S. District Court. And again, this is by law. That's the standard. It's been affirmed by the Supreme Court in the Eye for Eye decision a few years ago. So just a few features of district court litigation. There is very broad discovery, you may know in the United States, in patent litigation. Discovery can be very broad. It can be very time-consuming and expensive. The timing can vary. You have, normally there is a jury involved in the decision for both infringement and validity and damages. Typically, district court litigation costs more because of all of these features. So I'd already mentioned you can appeal to the Federal Circuit, Supreme Court. By contrast, for AIA proceedings, well, this just shows the two different types that are mostly used, but the important thing on this slide for our purposes is the upper right. The standard is called preponderance of the evidence. That's a lower standard of proof than the district court. Preponderance just means it's a little bit more than 50-50, so it can tip slightly towards one side. That standard was set by Congress for our proceedings as opposed to the district court. So it is a lower burden to prove claims unpatentable at PTAB. A few other features of PTAB proceedings. The discovery is much narrower. It is tailored. That's part of how Congress wanted to keep the costs down. There are 3 technically trained judges. There is no jury. The timing, as you saw in the prior slides, very predictable. The times are set by Congress on how long it needs to take. As a result, the costs are lower as compared to district court. So this again just shows what I said before, that after a final written decision, you can ask for rehearing from the panel, director review, and then in any of those 3 cases, you can go to the Federal Circuit on appeal. I would say most of the AIA trial decisions do end up getting appealed to the Federal Circuit because you have 2 parties, almost guaranteed one of them is going to be unhappy with our decision and want to appeal it. Ex parte appeals have a lower percentage. It's about 1% to 2% of all ex parte appeals end up going up to the Federal Circuit, but as you saw earlier, there are many more ex parte appeals than there are AIA trials. So I think we are not taking questions, if I recall correctly. So I thank you for your time, and again, thank you very much for the invitation to be here. Thank you.
ボアリック首席審判長、ありがとうございました。